is that once the defendant or that once the arrestee has surrendered and under control, you cannot continue the bite. He said, that's a statement of law, period. That's the law. That's what he said.
I got the feeling from some of the judges that they were saying nothing in his hands, dog was on the bite, nothing around them, no weapons, nothing like that. In their mind, it seemed to be they were painting the picture that that was control.
Welcome to Police K9 Radio. I'm Gregg Tawney. With me, Rich Hartman. Rich, what's going on?
You're in week 3 of the basic. You've got a couple weeks left before these guys go out and hit the streets, and no better time to have this conversation than now because there's a lot of lack of clarity, some concern about some time on bite issues, about when somebody is under control, when they're no longer a threat, and when we need to get the dog off of the bite. And in typical law enforcement / canine fashion, there's some knee-jerk stuff going on that maybe doesn't have to, I guess we have to be aware of it, but we don't have to start, throwing the baby out with the bathwater right yet.
Yeah. For those of you that have been around a little bit, like Rich and I, a little long in the tooth, I guess they say. I remember back when Smith v. Hemet came out, and we had agencies freaking out and putting their canine program on hold, and then the Lowry decision came out, and they're talking about what a serious offense is or what it wasn't, and burglary wasn't one, and everybody freaked out again. And so these other 2 cases have just recently come out that we're going to discuss. And again, we're getting that knee-jerk reaction, and we as an industry are sometimes our own worst enemy, and we start changing policies and changing the way we train, and the things haven't worked out. So instead of Rich and I sitting here trying to muscle through the legal jargon and giving you our 2 cents or $1.50, 3 cents with inflation, thanks Biden. We'll stay not political, but anyway, so instead of us going through all this, we're going to bring in our legal beagle.
It's been a while.
It has. Mike Kmiecik is on with us today. Mike, how are you doing?
I'm well, thanks. And just a side note, I know we're not getting political here, but all that's going to be fixed on January 20th, from my understanding.
Yeah, it's let's call it like it is. Like
times are changing.
Times are changing
for a little bit
for the better.
But I mean, and
we both are in.
Go ahead, Mike.
Well, we're both in states that are very, very blue that had a significant change in the electorate in the election. So interesting. It's just fascinating to me.
I always like talking to Mike because then it's like we're like brothers in commisery. Like it's like, how's it going out there in Chicago? For those of you who don't know, we'll give Mike his background, but he's out in the Chicago area, and it's like if there's one place that's maybe even a little worse than California, it's Chicago. So we can
Northern Virginia is right there too, and we have and Aaron who owns Ridgeside, and I talk to him all the time, and I feel like Nova's passed up California a little bit, and I know Chicago definitely wants to pass up California, and we talk about it all the time. I know there's a lot of thoughts about being a cop in California, but it's still good police work in California, and we are afforded some freedoms that I think some states that you would believe might be more, free. In California, cops still get to do police work slightly less unfettered than many other places.
Yeah. So, hey, Mike, for those of you out there that don't know Mike, can you give a brief background on yourself and, where you hail from and what you're doing?
So I just retired last year from my 28-year career as a law enforcement officer in the Chicago metropolitan area. When I retired, I had worked dogs, I should say, for 19 plus years, training patrol, drugs. I worked a couple cadaver dogs also in there. When I retired, I was the lieutenant in charge of the K9 team for the Northern Illinois Police Alarm Systems Mobile Field Force. So we handled all the mass arrest, crowd control outside the city of Chicago, but all of the suburban Cook County, Collier counties. I think we had like covered about like 634 square miles, population of 2.1 million people. In 2019, I took over for Terry Fleck after his passing. I created legal updates and opinions. Like Terry, I'm not an attorney. I am an instructor in search and seizure, use of force, I'm a certified Force Science Institute analyst. And I do expert witness work and consult with attorneys, generally defending officers and their agencies on use of force events, but more specifically on canine use of force events. I have done a couple of detection cases in the state as well. So just looking at this, well, one of the things that my company does with the Sheepdog Guardian Consulting is that we have an online law library for canine handlers, for canine cases, case law. We have a bunch of resources and articles that are up there, from everything from articles written by industry experts, all broken down by dog discipline, sample report narratives, things like that. So when I talk about these cases, as a non-lawyer, I do talk about these, from my experience, not just as a 28-year law enforcement officer, but also my experience as an instructor in these areas and working on these cases and consulting with the attorneys that are representing the officers as it relates to those cases.
And Mike, you also do a class. You came out to us a couple years ago. It is a great canine legal update class. What impressed me about your class is when you came out, we're obviously in the Ninth Circuit, and your whole presentation was geared around the cases that were affecting us directly. And that's something that we don't get a lot. Like if an instructor travels around the U.S., like it's like a canned, like this is, the same presentation everywhere. And so if anybody out there is looking for a legal update class, like, man, I can't recommend you enough. As a matter of fact, we've talked about having you out again here within the next year. And I know you've been busy with that.
Yeah, so that was like one of my arguments. I shouldn't say arguments, but disagreements that I had with Terry. Is he taught all over the country, and he canned the program. And trust me, it would be so much easier if I just did that. But I don't think that would be doing the officers any service to come to the Ninth Circuit and tell you all about what's going on in the Seventh Circuit in Chicago. It's not going to do anybody any good. So, I mean, it's incumbent on me. It's a lot more work for me. But that's what I try to do when we teach these seminars. I think, or seminars as it goes, I think we have one, maybe only 2 slots left open for next year. We're already booked up, I think, for next year, moving into 26. So,
hey, Mike, before we get going
busy.
into kind of the meat and potatoes of this, when you're doing those different seminars and you're doing the different circuits, does it almost feel sometimes like the law enforcement job in and of itself is different, like based on where you're at in the United States, like what you can do? Like it's almost impossible to can it, right? And say, hey, like a cop in Florida is the same as a cop in Idaho is the same as a cop in California. Like that's not the case.
But sometimes I wonder whether we're all operating under the same constitution, to be quite honest with you. I was just 2 weeks ago, I was up in Oregon, and hey, as a citizen, I would love to be a citizen of Oregon, although I hate the cold, because you have so many rights, but the cops have so little authority there because they just interpret their state constitution so much differently than other states do. And the states have the right to do that. They have the authority to interpret their own constitutions differently. But yeah, it's completely different. I mean, you would think it should be the same, at least as it relates to the federal Fourth Amendment, but the circuit courts have their own, they're their own animal in and of itself. I mean, the Ninth Circuit is, as of 2022, is the most overturned circuit in the United States. So the Supreme Court of the United States only hears about maybe 1% of the cases that it's asked to hear. So that leaves 99% of the cases that it's asked, they don't even hear. But of the cases that jump from the Ninth Circuit to the Supreme Court of the United States, the Supreme Court will overturn them in well over 80% of the cases. So they just don't agree. That's a very high turnover rate.
That should be a sign.
Yeah, it is.
But maybe the sign is you just want to be conflictual, I guess. Like you want to be the
I will
outlier.
say,
I
though,
don't think they care.
No.
prior to 2022, there was a several year stretch that the Ninth Circuit actually dropped to number two. That you guys had some judges that were appointed to the Ninth Circuit under President Donald Trump, the 45th president of the United States, and the 47th, that actually started to turn things around there in the Ninth Circuit. But then, after January 20th, 2021, they started appointing and getting judges back to the Ninth Circuit that maybe are not as friendly towards law enforcement as you would think. So.
Well, Mike, thanks for coming on today. There are a couple cases that have created this whirlwind, at least in our area, Northern California, and that both of them, Rosenbaum versus City of San Jose, and then Rock v. Miller. And we are seeing agencies and training groups and even at conferences, scenarios being designed around these cases. Could you kind of enlighten us on your take on these cases? And let's start with Rosenbaum.
Try it again.
Easy for you to say.
Rosenbaum versus City of San Jose. Can you start with that one? Kind of give us the background and some of the factual things that have occurred that are causing us concern.
Sure. So first thing is it's good to start with the Rosenbaum because that came out first. And as a matter of fact, if you listen to the Rock v. Miller oral arguments, Rosenbaum came out, published opinion came out
that day,
the day that they were doing the oral arguments for Rosenbaum, and the city's attorney had not read it. And he made a really good point, is that he said, okay, well, because Circuit Judge Desai had brought it up and said, are you familiar with the Rosenbaum case that just came out today? It's a published opinion. He said he had not read it. And even if he did read it, it wouldn't matter because it just came out today. So the officers would not have been on notice back when the incident happened. And what I think was interesting about that is while that case was not out, that would have put the officers on notice, the underlying foundation of that case, which is Watkins versus City of Oakland, California, was out long ago. I mean, that's the basis and the undergirding behind the Rosenbaum case. So first, let's just talk about both of these cases are interlocutory appeals. And the term interlocutory just basically means lack of finality. And an interlocutory appeal is an appeal of a non-final order from a court. So, in other words, it's mid-litigation appeal. When we, law enforcement, ask the court for summary judgment or summary judgment on qualified immunity grounds, if we don't get a ruling favorable to us, we have an automatic right to appeal the district court's decision prior to trial. And that's called an interlocutory appeal. So all of these are just, all this means is that these decisions, we have to look at them, I should say the court has to look at them in light most favorable to the plaintiff, unless there is blatantly contradictory evidence, such as video evidence. And that comes from a Georgia pursuit case called Scott versus Harris. So we're just midstream here. So in other words, no jury has resolved any fact disputes. No trier of fact, a judge has not resolved any fact disputes. So the court has to look at the pleading documents and the plaintiff's version as being true and accurate at this stage. So starting with Rosenbaum, does that make sense, by the way, before I move on?
I think so.
Yeah. Did I explain that?
Yeah.
Okay, so in the Rosenbaum case, you have San Jose. They respond to a domestic situation, a domestic violence situation. Rosenbaum's partner called, 911. So the officers go out there. He kind of flees back into his house. The officers enter the house, and they have less lethal kinetic impact weapons. They have their police dog. and they're kind of communicating to Rosenbaum. He's kind of up on the steps. For those of you who hadn't seen the video, you probably should watch the video. He's kind of up on these steps.
Real quick, right there,
Go
Mike.
ahead, please.
We're going to show the video. If you guys are watching it on YouTube, we are going to come up with a video for both platforms, our podcast platform and our YouTube. We're going to put the link to the video if you haven't seen it. And then we're also going to put links to both cases that you can actually watch the Ninth Circuit kind of deliberate back and forth with the attorneys. If you're a handler out there, man, you have got to watch this. It is really interesting to watch the attorneys present the case, and then it's really interesting to hear the Ninth Circuit interpret, spit it back at them, and then deliberate. Little scary.
It was a little. There was some pre-interpretation that was going on. The judges definitely showed up with a mindset.
You're under arrest. Walk down here now.
Why am I under arrest?
Walk down here now.
Why am I under arrest, sir?
Are you going to come down here or not?
Why am I under arrest, sir?
Because you want to talk to Zach, come downstairs.
Why am I under arrest, sir?
Let's leave. Okay, we gotta get ready. We gotta move. We have to move. Val, get behind the cover. Val, behind the cover. Hawkins, fighting the dog. Hey, you gotta keep pushing. Dave, check that. You guys, get your light up. Get your gun up. Hawkins. Hey, cover him. Cover. Boy. Cover these hands. Loose hands. Boy. We gotta get two guys on hands. Two guys on hands. Somebody get gloves up and get on the other hand. I got lethal. Copy. We need to cover these rooms. Boys. We're gonna have to step over him. I gotta get in the room. I gotta get in the room. Step with him. Yep. Lead me out. Just grab me out. Your arm. Go straight back down into that room. Out. Stay down.
It's scary, but it's important, like you said, Greg, for the handlers to watch and listen, because you want to understand how the court is analyzing and interpreting the issue, the canine issue that's before them. So it's really important to listen to what those circuit judges are saying, and we're going to talk about some of the things specifically that they said, and the questions that they're asking, because then you can kind of get an idea of, when cases get before them, how they're thinking about them, right? So it's really important for handlers to watch those or to listen.
So we were at the point, with that case, we were at the point now where cops are at the bottom of the stairs involved.
Suspects up on the landing, domestic violence incident. I don't think they had an issue with the grounds for the deployment. If I'm not mistaken, the courts were okay with the criteria was met for deploying the dog. Go ahead, Mike.
That issue wasn't even really before the court.
Okay.
The only thing before the Ninth Circuit was the actual duration of the bite. Mm-hmm. And so Rosenbaum kind of starts to retreat back upstairs. So you have this two-story. Officers are down. The officers are kind of, you have this stairwell, as you'll see in the video for your listeners, that kind of makes this kind of L shape. So you got the stairs that go up, there's a little landing, and then the stairs go up again. And that's where the bedrooms are in the back. The officers are, the dog handler's kind of just on those lower stairs, got the dog. He starts to retreat. He, being Rosenbaum, starts to retreat back into the bedroom, at which time they launch the dog. As the dog is biting, the officers have to kind of negotiate this narrow stairwell to get up to where Rosenbaum is being bitten. When the officers get up there, Rosenbaum's hands are visible. They get him proned out. And once the officers gain control over Rosenbaum's hands, the officer orders the dog to release. Now, the issue here is whether this 20 seconds or so that the dog remained on the bite, when Rosenbaum's hands are shown, he is thrown out on his belly with his hands out to his side, whether or not that became a Fourth Amendment seizure violation for excessive force. That's the issue, basically. When you break it down into a nutshell, that's going to be the issue. That's the issue in the case. What Circuit Judge Ryan Nelson said, this is how he kind of starts off. He starts talking about Watkins versus Oakland right away, right out of the gate. And so I think it'd be beneficial for your listeners. Let's talk about what happened in Watkins, because Watkins is a crucially important case. Now, Harry Fleck used to say that Watkins was one of the 5 court mandates. I don't like the term court mandates. I think it's better stated they're industry rules or standards. And in Watkins, you have a commercial warehouse, and there's a burglar alarm that goes off. Oakland PD respond. They see signs of forced entry, signs of criminal activity. They see Watkins running inside. Very similar fact pattern to Robinette versus Barnes out of the Sixth Circuit, where the dog grabbed the guy by the neck and killed him. Very similar. The difference is that Watkins, instead of trying to hide under the car like in Robinette, he hid inside a car that was inside this commercial warehouse, but the windows were down. So when the dog handler got there, made his warning announcements, he launched the dog. Of course, the dog simply needed to jump through the window and bite Watkins. Now, upon hearing Watkins screaming, the officers leave their breach point, their area of cover. They run right through the hot zone, right through the fatal funnel without any tactics whatsoever, straight to where Watkins is screaming from. And on approach, what is the handler doing? He's praising the dog up. Good boy, get him, get him, get him. And the court said, the Ninth Circuit that is that Watkins was recoiling from the bite. He was screaming in agony, recoiling from the bite. And Watkins was pleading with the officer, I give up, get your dog off of me, I surrender, I give up. And of course, what does the handler tell him? Famous last words from every dog handler that's out there. Dog's not coming off the bite until you're in handcuffs, right? And they actually wound up dragging Watkins out of the car, handcuffing him, and then releasing the dog. And what the Ninth Circuit said, succinctly, at least in the Watkins case, they said, we agree that it is clearly established that the excessive duration of a bite and the improper encouragement of a continuation of the attack by officers could constitute excessive force. That would be a constitutional violation, and therefore they affirmed the district court's denial of qualified immunity to the officers. In other words, they're saying it was clearly established, the officer knew or should have known that leaving the dog on the bite when the person, Watkins in this case, has fully surrendered and is under control of the officers, that the leaving the dog on the bite was a constitutional violation. In other words, it was excessive force. And so going back to the Rosenbaum case, they reiterated this several times. This has been the rule. That's a 1998 case. This was the rule that they established in Mendoza versus Block in 1994. There's another case that was out of Arizona. It's an unpublished case, Castro versus Martin. It's an Arizona DPS case. They said the exact same thing. So they have never come off of that since the mid-90s. So when
Mike,
a subject is... Yes, go ahead.
So, Mike, what we're looking for then on the handler side is, and I think the courts termed it right, once the suspect has fully surrendered and is under complete control, then we must have our dog release the bite. Is that from Watkins specifically, but that's our standard?
Yeah, that's the standard. That's the rule. Mm-hmm. And it started off in Mendoza versus Block. It continued into Watkins. I think Watkins is the undergirding of both the Rosenbaum case that we're discussing and the Rock v. Miller case. Mm-hmm. And it was also the undergirding of Castro versus Martin, which was, what year did that case come out? That was 2021. So they just keep re-announcing the same rule. So this is nothing new. And this is where I say we don't need to get so worked up and have a knee-jerk reaction, because this has been the rule since the mid-90s. It just has. There were some things, and I think where the disconnect is, where officers are having trouble with these cases, is what our definition as police officers of a subject who is under control versus what the court's interpretation of a subject is under control. Mm-hmm. There's a disconnect there. And quite frankly, I think courts are kind of struggle with that also. What is under control? As a matter of fact, they said it specifically during the oral arguments in the Rosenbaum case. They made it very, very clear. But getting back to what I was saying, now Judge Ryan Nelson, he comes right out of the gate, he says, listen, the holding in Watkins, which the officers are presumed to have read, and that's important. He said, the holding in Watkins, which the officers are presumed to have read and understand and guide their future behavior. In other words, what he's saying there is, you got to know your case law. Mm-hmm. Published opinions, you have got to know them. They establish the rule of law in that particular circuit. And then he went on to say, is that once the defendant or that once the arrestee has surrendered and under control, you cannot continue the bite. He said, that's a statement of law, period. That's the law. That's what he said. And he said, he did surrender. He surrendered before the dog bite even occurred, which I thought that was the interesting part right there. And he said, and then he asked the question to the city of San Jose's attorney. He said, how far did they need to go before they said he was under control? In other words, what he's asking the city is, at what point did the officers consider him under control? I think that's the crucial question in this case. And Judge Forrest kind of follows up with that. Danielle Forrest, she follows up with that. She says, is it the city's position then that Rosenbaum was not surrendered and under control until he was handcuffed? And the city initially agreed and said yes. And then Judge Sanchez jumps in there and he goes, whoa. That cannot be your position, right? That there has to be handcuffing before there's control. And then the city started to walk that back a little bit because that's a losing argument. Mm-hmm. That just is. I think that's a losing argument. Then the city attorney said, no, that's not what I'm saying here. Handcuffing is not the standard by which we determine the duration of the dog bite, says Judge Sanchez. And that's an important point right there. He said again, handcuffing is not the standard by which we determine the duration of the bite. In other words, the person does not need to be in handcuffs prior to the officers having control, right? And they went back and forth, and they were talking about Miller versus Clark County, a dog bite case out in Nevada. The court really distinguished between the facts of the Miller case and the facts of the Rosenbaum case. And they said that's really not, we just think that's distinguishable here. And Judge Nelson goes on and says, this man is laid out prone with his hands out to his side. He's wearing a tank top. So it's not, it's not like the officer, he could have hit a weapon. And this is where I think the city dropped the ball. Because as a Force Science Institute certified analyst, we know that the Force Science Institute has done a bunch of studies on timing offender attacks against police officers and police officers' responses to those attacks. And what they found is that a subject who is completely proned out can go from a complete prone position to a full-on attack on a police officer in 0.8 of a second. 0.8. It takes the officer about 1/4 of a second to even realize that he's under attack, which leaves them only about 1/2 a second to even start the reaction process. So I think that's where the city dropped the ball, because we could have brought in at the district court level experts who would have been able to drive that point home. Because that's, in my opinion, that's what's going on in the officer's mind. They know how quick, we all know as police officers, how quick somebody can go from that to a full-blown attack. And I think that's why there's this disconnect between what constitutes control, right? So let me just see here. They said, that was the one thing I want to talk about. Now, again, they just went on and they were really just going on Watkins. And then right towards the end of this oral argument, Judge Force says, this is what's really crucial for officers to understand. She says, the rule is, and then she paused and she said that once somebody has surrendered and is under control, you've got to let the dog go. And she paused again. And then she said, there is a timing factor there, right? That could happen on second 5. And then there has to be some time for the officer to recognize that they need to call off the dog. The facts presented a perception problem, right? And that's what she was asking Rosenbaum's attorney. Like, at what point did the officer actually see that Rosenbaum had surrendered, that he was under control? And then don't we have to allow him some time to recognize that and then make the decision to call the dog off? And I'm just going to say this. I think body cams have done generally a lot of help to law enforcement. But I think body cams have done a lot of disservice to the police dog industry. And what we need to understand about body cams is they have very limited abilities, because it isn't necessarily the perspective from the officer, what the officer is seeing. And what Rosenbaum's attorney's response was, because Judge Forrest was trying to get that, is the camera angle we're watching this from, is that actually what the handlers saw? And Rosenbaum's attorney said, oh, absolutely. It was exactly what the handler saw. And again, we could have presented evidence probably at the lower court level that could have disputed that fact and would have made it a little bit better for us. And what the city argued in the end was Watkins was not enough to put the officers on notice that leaving the dog on the bite in this scenario was a violation of clearly established law. Now, in the end, the Ninth Circuit, in their opinion, which is a published opinion, so that's the published opinions are what set the rule of law. They set the binding authority. We have to listen to those published opinions. What they said is, all they said really is, listen, we think there's enough dispute of fact here that at least let's let the jury determine. It may happen that the jury says leaving the dog on this bite for that length of time was completely reasonable. But at this stage of this interlocutory appeal, we're not the trier of facts. You know, we don't sit here and we're not going to resolve factual disputes. We're not going to determine the credibility of witnesses here. That's up to the jury to do. And that's all they said. And so they said, we agree that with the district court that the handler in this case was not entitled to qualified immunity because it was clearly established by Watkins. If you leave the dog on the bite after the person had fully surrendered and it was under the control of the officer, that was a violation of clearly established law. Now, they said in the end, maybe the jury says he wasn't under control. But what the court said is that's up to the jury to decide whether or not Rosenbaum was under control of the officers. And that's all that this said. Now, can we take some lessons out of this? Sure. Okay. Now, do we have to go to the extreme that, somebody is in a room, offenders in a room, we cannot see them, and he's screaming, get the dog off? Does that mean that we have to immediately verbally release the dog? I don't think that that's what this is saying. But once we do see that this person is in full surrender and overtly complying with our orders, in other words, under our control, overtly complying with our orders, then yes, we need to make sure that that dog is coming off the bite. That's all that they said, but that's been the rule. Honestly, there's nothing new that came out of that. We should have been doing that, to begin with.
Hey, I'd like to thank one of our sponsors, RAY ALLEN Manufacturing. They've been engineering tactical and working dog equipment like harnesses, collars, leashes for military police for over 75 years. They are continuously innovating. I always like to say, this is not your dad's Ray Allen. They are always looking for the bigger and the better. We get all of our handlers now in the basic handler course deal directly with Ray Allen. We get our harnesses, leashes, tugs, e-collars, gloves, Rec Specs, Hearing Dog Pro. All of our good stuff comes from Ray Allen Manufacturing. Look them up, rayallen.com. I cannot recommend them enough. We only recommend people that we deal with, and these are good people, and they're in it for the right reasons. So because of that, rayallen.com.
There seems to be some argument both in the Rock case and the Rosenbaum case from the bench that recoiling, moving around, grabbing the leash, those kind of things aren't necessarily
resisting.
Yeah.
Right.
Yeah. And I would agree, right? Like if I'm getting bit by a dog, I'm going to do some things that we're going to show that I'm not terribly comfortable with the situation.
But the recoiling issue actually that stems straight out of Watkins versus City of Oakland. That's exactly what the circuit said. They use that language exclusively, which is why the attorneys in their arguments are using that language, because they know that the Ninth Circuit's going to bite on that, because the Ninth Circuit already used that language. So they're going to use that. So there's an expert, a plaintiff's expert out there that's his boilerplate template, or one of his boilerplate template opinions, is that officers are not properly trained because they don't know a certain thing. So I'm going to go ahead and train all your audience on this, and now they're going to be properly trained, right? If you think about when you were a young boy or a young girl, maybe you're in the kitchen, with mom and dad, or grandma, grandpa, or whoever you're in the kitchen with, aunt, uncle, and you were cooking stuff up, and mom says, "Hey, don't touch the stove, little Johnny, that's hot." And what would you know? Well, of course, what were you going to do? You walk over to the stove, you touch it, and what was your initial reaction, right, when you touch that stove? Right? That's a natural reaction to pain. That's a human reaction. We grab where pain is coming from, right? A dog bite is painful, right? So if the dog's biting my forearm, as an example, right, I'm going to grab a hold of that, right? Because that is a natural human reaction. That is not resisting arrest, right? That's a natural. Let me put it this way. Think about the Kennedy assassination. I guess I'm dating myself, but we'll think about the Kennedy assassination, right? We know exactly when Kennedy gets shot, because what does he do? His hands come right here because he's shot in the neck, right? We grab where pain's coming from. And we need to recognize the fact that that's not resisting arrest. And going back to your point, Rich, this is where the courts are completely split on. Each circuit has their own interpretation of what constitutes active resistance for purposes of use of force under the Graham factors, right? So as a reminder to the audience, right, these use of force incidents are going to be analyzed, especially dog bites, under Graham versus Connor. And there are three primary factors that the Ninth Circuit, they call them primary factors in Graham: the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, and whether the person is actively resisting arrest or attempting to flee the arrest. So you got to know how your circuit interprets the active resistance part.
No.
And so what your court is saying, right, that recoiling from a dog bite or grabbing where that pain's coming from, what they're analyzing, saying, listen, that we don't think that's active resistance.
Well, and
a jury might find so, but at this stage, it's not.
Okay. And Mike, if I'm sitting there and I'm listening to Police Canine Radio on my my phone, right? Not the radio.
On the radio.
I think we said that one time a while ago.
There's still radios out there.
I'm listening to it on my phone, and I'm like, okay, well, I've been taught in the academy what hurts people, right? What hurts us? Hands. So I want to see hands. I want to have control of a hand. I don't believe the suspect is under control until I have that hand. So now the job becomes, is he recoiling in pain and he's reaching underneath him? Or is he reaching underneath him to a waistband? Because if we have a dog in play, like we have a serious crime, we have a possible belief that he's armed, and now his arm is going in underneath him, and now I've got to make that decision of, is he recoiling in pain or is he actually reaching for a weapon? And, you know, where am I gonna default to?
Actually, and in Rock, the judge actually came out and kind of fought for the appellate, I guess, because he did have his arm underneath, and she said, I believe that the officer kind of held it there in attempt to pull it out, which doesn't make a lot of sense, but she kind of blamed it on the officer. Like him trying to pull that arm out caused it to stay under him longer.
Yeah, that was Judge Desai. You could tell right out of the gate, I think, just listening to her line of questioning, he was not interested in hearing about the handler in this case. She was more interested in the bystander officers and the failure to intervene than she was anything else, which was kind of interesting. I mean, she said that right off the start. But yeah, Greg, you bring up a good point, and we really do not have a good answer for that. I mean, officers, if they're going to leave this dog on the bite because of what you're talking about, right? I can't determine if he's recoiling or if he's reaching for a weapon. They're going to need to articulate why they left the dog on the bite, and they better be able to explain that, and not just explain it in an IA investigation to a bunch of cops who, you know, whatever. They're going to need to be able to explain that at a deposition, and they're going to need to be able to explain that to a jury, right? Why did they think it was reasonable to leave that dog on that bite, and why they thought that the person wasn't recoiling from the bite, or why they believed, or why they weren't sure if he was recoiling from the bite or if he was reaching for a weapon, putting themselves in an immediate danger. And interestingly, on this point, going back to Rosenbaum, what the plaintiff's attorney, Rosenbaum's attorney, tried to argue, hey, there were all these cops there. They had their guns out. They were surrounding him, and they had the entire house surrounded. And there was just no way that he could go anywhere. And Judge Nelson, if you listen to him, he shot that down right away. He goes, wait, no. So those are two completely different things. These officers don't know. That's not the standard here, is what he said. And I thought that was really interesting. So he kind of shot that down. So you at least have one judge that on the Ninth Circuit that at least is thinking. I think if we would have gone in there and been able to explain, listen, this is how fast people can attack from a prone position. Here's where it's going to be. It's just going to be this critical. The officer, the handler, the dog handler needs to explain, this is when I saw the offender. This is when I recognized that he was in full surrender and under control. And based on that, that's when I released the dog. That's going to be the crux of what the handlers are going to need to articulate in these cases. Now, I think that these Ninth Circuit cases are 100% the rule across the industry, no matter what circuit you're in. However, the Seventh Circuit acknowledged in a case called Johnson versus Scott that police officers do not always have to take a suspect's apparent surrender at face value a split second after it happens. Because by doing so, that might allow the time for the offender to gain access to a weapon and murder the officer, and that's not acceptable. But in the Ninth Circuit, and I think all over the place, as soon as the handler can articulate, let me back up. What they need to articulate is, this is when I saw that the suspect was in full surrender and under control, and based on that, that's when I gave the immediate release of the dog, or I gave the release of the dog. And I think if you can articulate that, I think you're going to be able to be in good shape.
Once again, this episode is brought to you by INUKSHUK Professional Dog Food. There's only one brand of dog food that we use and recommend. That is INUKSHUK Professional Dog Food. INUKSHUK was created for working dogs and continues to be the top choice for all working dogs, from hunting dogs to sled dogs, and of course, police canines. Whether it be detection or patrol canines, visit INUKSHUKPro.com, or you can find all of the formulas on Chewy.com.
Hey, everybody. We got a canine supervisor course coming up for all supervisors, and not just supervisors, the unit leaders. It's coming up in Elk Grove, California, April 28th, 29th, and 30th. I do this class with Bill Lewis. We go top to bottom. We do case law, selection and retention, defending your canine program, canine use of force. We get into some training, reality-based training, public relations. We do it all. You can find more information by going to Tactical K9, K the number 9, USA.com, or on my website, dtack9.com. Hope to see you there.
Mike, on a devil's advocate side, because it seems to be that's what the judges are doing, and being a little bit of a devil's advocate in some of this. Give an example, and it's kind of part of the rock case, but say I'm in a backyard. It's about a third of an acre, big backyard. Suspect committed some kind of robbery or something big enough where they're getting bit by a dog. They're behind a shed, but they're 40 yards away. Dog apprehends the guy. The guy kind of comes out from around the corner. He's got the dog on the bite, and he says, I give up. I don't want to fight anymore, but he's 40 yards away from me. Is it my responsibility? And I've got good covers here with me. I've got lethal cover. I've got less lethal cover. I'm in charge of the dog. He comes out into the open. I don't see any weapons. Both of his hands are visible, and the dog's on one arm. Is it my job to immediately say, dog, let go and come back to me? Or do I have the benefit of moving up, maintaining control, and then getting physical control of the dog and physical control of the suspect? Because I got the feeling from some of the judges that they were saying nothing in his hands, dog was on the bite, nothing around them, no weapons, nothing like that. In their mind, it seemed to be they were painting the picture that was control and surrender.
Yeah, I agree. I think, again, so I go back to, okay, I can see the person's hands, right? It is an apparent surrender. And if that person is overtly complying with my orders, and this is going to use your scenario, then I think at that particular point, we should be giving the verbal release command, right? We should be trying to get the dog off. And quite frankly, it's safer for us too. We're 40 yards away. We're behind cover. Why would we, even if we have good cover officers and all that stuff, why create an unnecessary risk to our safety when we could just call the dog off, bring the dog back to us, and we can get that suspect, if he's overtly complying with our orders, we can get that suspect into a position that we want them in now, right? Because, ordering this person, the dog's biting him, like you said, now we see him, he might not be in a position that's most advantageous to us in law enforcement to approach, right? So I want to get him into a position that is going to be most advantageous for me. Well, leaving the dog on and saying, hey, bring the dog over here, bring the dog over here, bring the dog back to me. The Seventh Circuit shot that one down recently also, Davis versus Allen. It's a Wisconsin case. So I think at that point, given the facts of the scenario that you just presented, I think that the court is going to say we need to do a verbal release. And I to be quite honest with you, I'm not necessarily disagreeing with that. Again, I guess, from a tactical standpoint,
devil's advocate.
Go ahead,
again.
Greg, I'm sorry.
I guess we're the devil's advocates today. We did a debrief on an LAPD deployment 3 or 4 episodes ago where they find a suspect, stolen vehicle, felony evasion. He foot bails, jumps into a backyard. Dog is on the bite. He's appearing, his hands are up, and he's kind of going down to his knees, and they verbal out the dog. Then he jumps the fence. He breaks into 2 more houses. They wind up finding him again, and that could have been a lot more use of force on that end. And I guess that would be my argument, is I don't have control of him because he's 40 yards away or 40 feet away. Once I verbal out my dog, then he can take flight again. We've had officers do that on robbery suspects, and the suspect took off running again, and then they're running after him again, and it continues. We've had that on more than one occasion with some of our handlers. So, I feel like it's almost a no-win situation, right? Like, now I've got a verbal out. I don't have control of him. He can reach behind him. Yep, we have lethal on him. He can turn and run. We're generally not going to use lethal force there. He jumps into somebody else's backyard. It goes on and on and on. Maybe breaks into a house. And I know I'm maybeing, right? And maybe maybeing's too much. But that's right. That's our train of thought. Where before we would say, "Hey, let's push up, grab that arm. You got that arm. I'm taking the dog off." And then we don't wait for cuffing, but we get an arm. That way, he can't reach for a gun or he can't take flight again. Where does that argument lie? What are your thoughts?
I think the Ninth Circuit has made it very clear. If that person, even if they're at that 40-yard mark, right? If we can see them and they are overtly complying with our commands, I think the dog needs to come off. And if that guy decides to run and, we re-dog him, I think now we have a stronger argument, right? That the second time that the dog apprehends him, now we're going to leave that dog on until we have physical control over him. I think we have a stronger argument because his actions just prior demonstrated that we did not have full control of him. So we don't have a case that I can think of off the top of my head that is directly on point that would give us any guidance from anywhere in the country. But just when you just parse this down, when you look at Mendoza versus Block, now in that case, the officers, that's a bank robbery case. For those of you who don't know Mendoza versus Block, it's an armed bank robbery case. He comes out of the bushes, the dog is biting him, and they left the dog on the bite until Mendoza was handcuffed. And the Ninth Circuit said, under the circumstances and the facts of this case, we think that was appropriate. And they acknowledged in the oral arguments in Rock versus, in the Rock case, they acknowledged that they allowed the dog to continue to bite in Mendoza until he was handcuffed, but then also immediately following that said, well, but we walked that back in Watkins. So I understand what you're saying, Greg, and we can, until the court directly answers that question, I think, in my opinion, and again, I'm not a lawyer, but just as a law enforcement instructor, I think they answer the question. I think they answer that question, and the answer was, dog's got to come off. And if the guy runs again and we wind up re-dogging him, because now, we still have, again, we launched this dog because this person has committed a serious crime. They presented some immediate threat to the safety of us or others. If they then start fleeing after the dog was released, those two factors haven't changed, right? As a matter of fact, I would argue that the immediacy of threat goes up, plus we have a continuation of an attempt to flee. So I think we're good there. And then I think we have a stronger argument as to why we should leave the dog on the bite. But
in my opinion on this, I think it probably isn't very popular, but I feel like it's like a 40 millimeter, right? Some guys at that same distance, he's doing something. Mm-hmm. I shoot him with a 40 millimeter. He said, oh shit, that hurts. I give up. I don't get to keep shooting him with a 40 millimeter until I go to contact him. I have to stop. And if he gets up and runs, then we start all over again. That's on him and we react to it, but I don't get to keep that force applied to him because I haven't reached him yet.
Yeah, the only difference would be once you recalled the dog back, and like happened in the LAPD situation, the guy made it over the fence before the dog could get to him. Where a 40 projectile, I'm going to be able to continue
with another one.
I'm going to be, and I'm not debating it. I'm just, from the way that we have operated in the past, it was, hey, we have control when we have that arm. And to your point, Mike, to your point, like that's no longer the case. Like our definition of control and the Ninth Circuit's definition of control, we are like in two different worlds here, right? And I guess they have the pleasure or the comfort of doing this from hindsight behind a bench when, we're out there in the dark and we think this guy might still have a weapon, and now we're trying to split that hair of, is this excessive or do I actually have control?
But report writing.
Oh, 100%.
But report writing is going to solve a lot of these problems, because I think is what we see
100%.
Is the officer can definitely explain what was going on and why they didn't think the person was under control, but they don't. They just say, dog was on the bite, I went up to him, got control. Well, there's a lot of things that happened between the dog was on the bite and you went up and got control that you can explain. Like that, the top of the landing in Rosenbaum, is a shit show. Like, that's a wreck. It's a narrow hallway. He was seated at some point and he moved into that prone position. He had access to 3 different rooms. He didn't have a shirt on, but he had shorts on. His hands were right down by his waistband. I don't know what he can conceal in his shorts. There's a lot going on there that never got explained. It was just, we got him into the prone position and then the officer had to get up there and even the lawyer for the city started talking about, well, the other rooms haven't been searched, completely irrelevant, kind of went down a path that didn't help the cause out any. Sorry. I know she's way smarter than I am, but.
No. I know, I agree. I think there was other arguments that would have been better suited under the circumstances. But Rich, really, your analogy with 40 mil, I think is spot on. It's the same thing with the taser. Right, I cannot hold the taser trigger down. I have a 5-second cycle. Think about that for a minute. Tasers are 5 seconds, right? It's a 5-second cycle. I have 5 seconds to get that person cuff under control. If that doesn't work, I can go ahead and initiate another cycle, 5. Right? Another 5-second cycle. Another 5. But according to the research, even Axon's own protocols, right? We don't go more than 3 cycles, 15 seconds, right? And we're talking, and then let's put that into perspective. We're talking 40-second dog bites, right? We're talking, in this case, in the Rosenbaum case, they're talking that the dog remained on the bite when Rosenbaum was in full surrender, under control for 20 seconds. So if you just look at this, if we just put that into perspective, right? We don't have other law enforcement tools that apply that same type of force for that duration. And I think that the 40 mil or any less lethal kinetic impact tool is a good analogy. Same thing. And I get it, Greg. I understand what you're saying. And as a cop, that would piss me off if I call my dog back and then this guy takes off running and I can't get my dog, refocus enough time and he gets away from me. I'm going to be pissed off.
Well, and
but in the end,
and I'm tracking with you 100%. I know there's handlers listening to this, and I get your frustration because, like the LAPD suspect, broke into 2 more houses. It's not just the frustration on the officer side. It's like, hey, we've searched, we found him. Now he's jumping into other people's yards. He might be breaking other people's houses. But your point is well taken. We got to play with the rules that the courts are giving.
And here's what we do 100%. But here's the thing. Why is that not happening now? And I'm going to tell you the reason it's not happening now, generally, is because we are going up and at least taking physical control over the person, like you said. That's what generally is happening across the country, right? Now, if we all start doing what the Ninth Circuit says that we should be doing, right, under their definition of fully surrendered and under control, and people now are repeatedly running away from us and breaking into other people's houses to escape, and then we go back and say, listen, we followed your rules don't seem to be working, and here's the evidence to support why we need physical hands-on control of this person. I think we're in a different position, but right now, if you look all over the country, there's limited arguments to say that's happening on a widespread basis right now. I think if we do this and then that starts happening, well, we're in a better position to go back in the court and say, listen, we did what you said that we should do, and now look at what's happening.
And I think we've seen enough crappy videos of cops taking a whole lot of time to handcuff somebody when the dog is on the bite, and we're all cringing, because, hey, just so you know, Mike, there's a big strapping guy walking around in your house. I don't know if everything's okay behind you, but when you go to stand
up, it's my son that keeps walking back and forth. Yeah.
He looks ginormous.
It's my youngest kid. He is. It's my youngest kid. It's like I powers over me now, right?
But as what I was saying, and I think we go down this path, whether it's live PD doing detection, stops where the officer is clearly involved with the dog, or these putting the person in handcuffs that's being bit by the dog, and the handlers praising up the dog and telling him what a good boy he is, and telling him, the suspect to shut up, and you're not, we're going to get you. Like, there's a lot that we can do for ourselves. Report writing, if two people are on the suspect, we can probably get the dog off and feel comfortable that they're under control if two cops have them. And, if need be, we're still 6 inches away from the suspect. We can there's a lot we can do to protect ourselves and make it look better.
And we've got to hey, okay, everybody glove up, everybody pulling out their gloves and freaking moving up.
Yeah.
It's like,
well, see, and that's the other thing. You watch that video, which you guys are going to show, right?
Mm-hmm.
We know that we're deploying the dog, right? Let me just put it this way. There's a substantial chance we're going to deploy the dog, right? And then you hear, oh, glove up when the dog's on the bite. Well, that should have probably have happened prior to the dog being launched, right? That would have cut down on some time on that bite. But you hear that's being articulated on these body cams, right? Oh, glove up. If you know that there's a substantial chance we're going to launch this dog, then your officers have to be trained, right? They get those gloves on right now before we do this, so that we're ready to go in those circumstances. Now, obviously, there's going to be exigence in that where something kicks off, you don't have time to prepare for that. You're launching the dog, but in scenarios like this where we do have a little bit of time to deliberate, they were in the house for 9 minutes, according to the court record. They were in the house for 9 minutes prior to deployment of the dog. So, in 9 minutes, we could have started getting people gloved up and things like that. But this is all hindsight stuff. This is just learning lessons, takeaways that I still don't think these. I don't think these officers did anything wrong. To be quite honest with you, I think.
Before we finish, Mike, can you do everybody a favor? Can you give a 20 or 30 second, and everybody should know this by now, but can you give a 20 or 30 second overview of what happens to an officer when they lose qualified immunity, what the results are or could be? Because I think that's all. Gregg and I were talking about this when I started my career. There was a whole bunch of, you got to put your house in somebody else's name, bury all your cash in the backyard. You're going to get sued every day, and somebody's going to take your house, and then the suspect's going to be living in your house and married to your wife.
Yeah,
it was all
with your dog.
Your dog. Yeah.
So really quickly, qualified immunity. The court, when we ask for qualified immunity, we're asking for summary judgment, and then in the alternative, qualified immunity on summary judgment on qualified immunity grounds. Summary judgment just means that when we look at the facts, the undisputed facts of the case, that as a matter of law, the officers did not commit a constitutional violation. Qualified immunity, on the other hand, the court says, based on the undisputed facts of the case, the officer did violate a constitutional right, but it wasn't clearly established when the officer committed it. So in other words, there would have been nothing that would have put the officers on notice that what they did was wrong. Now, the reason the officers lost qualified immunity in this case, as we talked about, the judge said that the clearly established law, the officers knew or should have known, they should have read, they shouldn't have known Watkins. That's what set the rule in. So they denied qualified immunity. So what does that mean? It just means we have to go to trial. That's it. That's all that it means. We have to go before a fact finder, a trier fact, and we need to present the case to them. Now, obviously, judge or jury, right? And I know I'm not in the business of predicting things here, but I think if this case is presented, both of these cases are presented to the jury correctly, they're going to win them. If they're presented correctly, they're going to win these cases. It's going to be a matter of both cities, San Jose and Goodyear, getting out the danger that the suspect posed in the positions that they were in while the dog was biting them. And I think if they can bring in some Force Science Institute guys, they can come in there and just clean up the carpet with this and just show this person was a threat. He maintained his position to be a threat. He was not under control. And once the officers gained control, the dog was released. I think they win it. It's just a matter of how they present it to the jury.
And what you said there reiterates write your fucking report detailed. Like, don't just sent dog, bit guy, went and took the dog off into store. Like, you have to be, especially Ninth Circuit, you have to be detailed in everything you were thinking. Make it very clear why the dog was on the bite for the amount of time that the dog was on the bite, what you saw, what you believed, what you saw in the surroundings. There's just a lot that you can talk about and kill them with details.
Yes. You cannot give too many of the right details. Because you want to tell a story, right? It's all about telling a story about not just, oh, this is what happened, but why did this happen and how did I feel as it was happening? It's all about just telling the story and laying it out.
Yeah. One addendum here, because it's something we're working on our side in training. We get handlers that get stuck into this. I'm in basic handler mode. And they just keep praising their dog in training. Good boy, good boy, good boy. And this inappropriate encouragement thing keeps coming up. I think you hear it in the Rosenbaum. I think you hear a couple good boys, and the dog doesn't need it. And I think it's a training scar. And so for you handlers out there,
yes,
we've got guys that have several street bites, and I'm catching them in training. Good boy, good. Cut it. Because, they don't realize they're doing it on the street, and it's become a thing that they're doing in training. Remember, train like you fight, and they're doing it subconsciously. And so in training, you've got to stop encouraging your dog, because it rears up. I see it over and over again. And now we even got handlers catching each other like, I heard you. It's like, God dang it, I know I said what I said it. It's like, we got to stop doing that. And the courts they keep beating us up on this point.
Listen, I agree with you 100%. I'm with you. I think if it's a brand new dog that's never bitten on the street before, I think we could probably have a real good argument and can explain why it happened. Why the handler gave the dog a praise. It's the first street bite, all of that. But then after that, I would say absolutely not. But that first street bite, I would be comfortable walking into court and saying to a jury, listen, this is why this occurred. Again, it's just explaining why. This is a brand new dog. He's young. He's never had a bite, blah, 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 blah. I think we will be able, we'd be in a much stronger position than such as the Watkins case, right? But there was a lot more. The context, we got to look at the context. And this is what I cannot stress this enough to officers. We got to stop eating our own, number one, right? We cannot make a judgment about what another police officer did based on a 10 or 15 or 30-second clip on the Constipated News Network we know as CNN about what the officer did was right or wrong, right? We got to understand the full context, because not only in Watkins was the handler praising the dog, but he also had time to tell Watkins, I'm not going to take this dog off of you until I got handcuffs on you, and then proceeded to drag him out of the vehicle while and continuing the encouragement. So there's other context there. Now, I think there are certain times that we may be able to articulate and explain why it would be appropriate. But generally speaking, Greg, I 100% agree with you. You got to stop that. Seasoned dogs, veteran dogs, dogs that have street bites under their belt, there's no reason to be doing that. I think that's got to stop. I agree.
Hey, we just went 5 minutes over an hour before we leave. I got to ask a quick question. Idaho, is it still a trespass for a detection dog to touch the wheel well thing? Is that all cleared up? On a car stop, there was an issue where if the dog's nose touched the car or
intermeddling, I think.
Yes,
yeah, that's State versus Dorf. That is, that's still, they haven't come off of that yet. And as a matter of fact, that's becoming the new argument on the detection dog side of things. And we're starting to see some of the courts topple on this. We just had a adverse ruling out of the Court of Appeals of Texas, 14th District out of Houston, State versus Oregon, which is causing a conflict in their state courts because another Court of Appeals there said otherwise. The Illinois Appellate Court just implied that the dog touching the vehicle prior to alert behavior would be a trespass. So we are starting to see this. Right. Number one issue on the patrol dog side of things, duration of the bite.
Mm-hmm.
The two most important things on the detection side, queuing, handler queuing, and this trespass issue. That's the new one. They're just making those arguments. So
yeah.
Does getting rid of the final
depends on the court you're in.
Does getting rid of the final response help with the queuing as far as a trained final response? Like getting ready to sit in the down, like, and just having them lock up. Does that seem to be a solution to the queuing issue?
What I think is understanding what final alert means versus alert. The final alert is part of the alert, right? It is
Final
the
indication.
culmination of the alert. It is a combination of all the changes in behavior. It's not the alert. And handlers need to realize it's the dog alerts. They need to describe that change of behavior.
Mm-hmm.
And if the dog has a final alert or indication, trained final response, whatever, then you describe that in there. But the trained final response in and of itself is not what creates probable cause to search the vehicle, right? It's the alert, right? And it's got to be, here's the key to that, though. I know we're out of time, but it's demonstrative behavior. In other words, what does the handler see and or hear? And demonstrative means anybody who's viewing this dog on a body cam, gas cam, cell phone, whatever, could say, hey man, the dog did something there. You know, what that something means, that's up to the canine handler based on training and experience. And for alert behavior to constitute an alert and probable cause, it has to be predictable and repeatable, right? So how do we show that it's predictable, repeatable behavior?
Training
in our
records.
training record. So you have to have documented that prior to it being on the street. That's a whole completely, different discussion.
Well, we have something to call back for
in and of itself.
We'll chat about that one again because
Absolutely,
I think
my friends.
I think it's really important, Mike. It's about an hour and 10 minutes. This has been a great conversation, and it's helped clear some things up for us. And I think the big thing is it's helped clear some things up for handlers, that are hearing a lot of rumors, and they're seeing some of these arguments, and they just kind of want to know where the court is going with this, and you've kind of lined that out for us. And I think it's really important for each handler to be able to justify what they're doing with their dog and know why they're doing it. I think that's the big thing. Know why you're doing it. If you keep them on the bite a little bit longer, explain why.
Mike, how do people get a hold of you?
It's all about why. Why?
Yep.
They can come to our website, which is www.sheepdogguardian.com. All of our seminars and our services and everything are up there.
Yep, you're doing them all over the country. Got a bunch coming up.
We do. Oh my God, I should go down this road. We're going up to our last one for this year, which we're going to be in Nebraska. First time we're in Nebraska, so that's going to be exciting. And then we start fresh next year. We'll be Alabama in January. See you guys down at the International Police Canine Association in end of January down there in Anaheim.
Mm-hmm.
We'll be out there, and we're going to be rocking from there on out. So
Yeah,
Cool. We just got back from Nebraska. Have fun. Lots of corn.
you did.
Or I did. Yeah, I guess I did. So anyway, Mike, thank you very
Lot
much.
of
We
wind.
appreciate your time. Yeah, exactly. We appreciate your time, and congratulations on the retirement. I think it's the first time we've talked to you since you stopped doing that
Some
gig.
retirement, yeah.
So congratulations on that.
listen, I'm telling everybody, retire at your earliest convenience. It's a wonderful thing.
Agreed. Retire, then get back into what you love.
Take care, Mike. Thank you
All
very
right.
much.
Thank you.
Well,
do me a
thanks,
favor.
guys.
Don't log
All right,
off.
be safe,
until,
everybody.
Yeah, don't log off until you're completely uploaded for us. Thank you.
Until then,
Train hard.
be safe.